Good afternoon and welcome to the third and final of the fall PIA webinar series. Today we have two guests joining us, Mr. Adam Karakolis and Stacy Stevens. Stacy's practice is entirely devoted to helping people with serious personal injuries. Her practice is restricted to ensuring people injured in car accidents, motorcycle accidents, boating accidents, slips, trips, and falls who have been denied access benefits or disability insurance benefits, as well as victims of acquired brain injury, receive full compensation they deserve. Adam joined Thomson Rogers in 2019, but he already has obtained trial experience. Adam's experience includes, but is not limited to, car accidents, motorcycle accidents, slips and falls, boating accidents, birth trauma, and acquired brain injuries. Adam understands that achieving results for his clients requires not only skill and intelligence, but also passion, creativity, perseverance, and above all else, hard work. Please welcome Stacy and Adam. Thank you.
Thanks, Melissa, and welcome everyone to our third and final fall webinar series. Today, we're going to talk about tips for brain injury survivors and important things to know. So I'm going to let Adam take it away from here.
Great. Thanks, Stacy. Thanks, everyone, for joining us on this beautiful fall afternoon. I hope the weather for you or wherever you are is as nice as it is for us in Toronto. And what we're going to do to start is we're going to go over maybe some things you might have learned from the previous presentation, which is I've hired a personal injury lawyer, what now? And we're going to give you our important tips, and we're going to weave those tips into the steps of a lawsuit, as you might have learned from the past presentation. After we go over tips and important things that we think you need to know for the course of your lawsuit, we're going to switch and we're going to talk about some important tips and things that we think it'd be helpful for you to know for after your lawsuit. So this is kind of our roadmap for the lawsuit itself. So we'll deal with the pleadings, how to deal with medical professionals during the course of your lawsuits, the affidavit of documents, examinations for discovery, pre-mediation, which we think to mean steps you can take leading up to your mediation, tips for the mediation itself, and tips for the trial itself. Now, if you don't know what some of these words mean, that's okay. We're going to be doing a bit of a review as we give you our tips so that this information is fresh in your mind so that you can understand the tips we're giving you, because we think it's important to review. So let's start with pleadings. So a pleading in your case for negligence involves your lawyer filing what's called a statement of claim with the court. A statement of claim sets out who the parties are, that being you, the survivor, the people who are responsible for your injury. It will set out the facts of what happened to cause your injury. It will set out what you say that the person responsible for your injury did wrong. It will set out your injuries and impairments, and it will set out some of the law or what we call legislation that you believe is helpful to the court with your case. Now, before your lawyer files that statement of claim with the court, they're going to meet with you. They're going to meet with you to get an idea about what happened and your injuries and impairments. Some of our tips: first, you should speak to your lawyer about how your accident occurred or how this event that caused your brain injury occurred. Give your lawyer as much detail as possible. Sometimes we give details and the lawyer doesn't end up using them in the statement of claim, and that's okay. Your lawyer is trained in the law, and your lawyer will be able to take what information you give them and siphon out what is important and what should go in the statement of claim and what might not need to go in the statement of claim but may be useful for later. It's good to provide as much detail as possible for that reason. Let your lawyer decide what is and what is not important for the purposes of your case. Another thing to do is to tell your lawyer about your injuries and impairments. If you're having other injuries aside from your brain injury, it's important to tell your lawyer about those injuries as well. Impairments are things related to your injuries that affect the way that you live your day-to-day life, the way that you work, the way that you do activities you enjoy, or things that you do to care for yourself in your home. It's important to give your lawyer as much information about your injuries and impairments because those get listed in the statement of claim. Now, while it might be daunting or it may seem difficult to you to think about your injuries and impairments and list them all out, what we'd encourage you to do is not only make a list yourself, but also talk to your family members, talk to your treatment providers, see what they say. They might have things that you might have missed or you might not be aware about. And it's important to curate those and get them to your lawyer. A tip that goes hand in hand with that is to tell your lawyer where and with whom you are treating so they can write for your clinical notes and records. So clinical notes and records, it's kind of the law industry term to refer to just what's in your file at your doctor's office or your physiotherapist. And the reason that it's important to tell your lawyer where and with whom you're treating is because your lawyer is going to write to those people and ask for their records about you. And your lawyer is going to take a look at those files. And they're going to use those files to determine what your injuries are and impairments are as well. And why it's important to do both is because you may have insights into injuries and impairments that didn't make their way into your treating provider's records. You may be experiencing something, for example, let's say you're experiencing dizziness and that just doesn't show up in your doctor's records for whatever reason. When you tell your lawyer, they can add that to your statement of claim. Now, for the same reason, it's important to get your clinical notes and records because your treatment providers may identify impairments that you don't remember or you don't have the words to describe. So it's also important for the lawyer to have those so they also go in your statement of claim. So in summary, before the statement of claim gets drafted and filed with the court, it's important to sit down and take the time to really think about what happened, what your injuries and impairments are, and to communicate those to your lawyer. I would encourage you to make a list. If it helps you to write it down. And I would encourage you to talk to other people in your life who may know about it, people like friends and family or your treatment providers themselves. This is the information gathering process. So it's important to do your best to do that at the time. Stacy, if you don't have anything to add, I'm going to jump to the next slide.
Nope, that's good.
Great. So now we're moving forward. Your statement of claim is issued, and this is something that happens both before, during, and after your case. But this stage is dealing with medical professionals. So you're going to interact with not only your own family doctor, but other treating and assessing professionals throughout your case. I'm sure most of you are familiar, but here's some examples. Occupational therapists are going to take a look at your impairments and they're going to see how they affect your life. They're going to see how they affect your ability to work, how they affect your ability to do self-care tasks. For example, self-care tasks might be washing your hair. They might be taking medication. They might be, cleaning your room, cooking, that kind of stuff. And they will also assess housekeeping, which overlaps a lot with self-care activities. But housekeeping can be things like shoveling the driveway, taking out the garbage. What they really do is they look and they try to find the impact that your injuries and impairments are having on doing what we call in law your activities of daily living. A speech and language pathologist, they're going to take a look at any communication issues, which we do know occur a lot in folks who survive a brain injury. They're going to assess what these deficits are. They're going to help you plan to overcome these deficits, and they may recommend or give you treatment to help you bring your speech back to baseline or as much as that is possible. Psychologists, they might diagnose the mental health that's associated with your brain injury or just the symptoms you're experiencing from the accident. Mental health illnesses they diagnose or conditions like depression, anxiety, post-traumatic stress disorder. They can also be found in people with brain injuries. A neurologist is going to look at your brain functioning. They're likely the ones that are going to be involved in diagnosing your brain injury itself. They'll look at also deficits your brain injury might cause you. Things like planning, things like what we call executive function, which is involved in your planning. It's your ability to think ahead. It's your ability to juggle tasks. Things like your attention. A neurologist can help you identify not only the brain injury, but the deficits that come along with it. Dietitians. Nutrition is important. It's important to the trajectory of your recovery from your brain injury. A dietitian may work with you to make changes in your diet or improve aspects of your diet that are lacking so that you can help manage your symptoms and improve. Ophthalmologists, they're going to look at your eyesight, and there are vision deficits that often walk hand in hand with brain injuries. An ophthalmologist is going to assess those and see where your functioning is at, and they may also prescribe treatment as well. So we've noticed in our cases that it's very important to make sure that everything gets communicated. A brain injury survivor is often dealing with a host of impairments and issues in their daily life resulting from their brain injury. And unfortunately, because memory impairments often walk hand in hand with a brain injury, it might be difficult to communicate those to your physician or your treating professional. So we have a couple tips to make sure that that professional understands all your deficits. So bring a list of your deficits to your appointment. Sit down, take some time before the appointment, write them down, leave that list, wait a day or two, come back to that list again, see if there's anything that you might have missed in the first go around. You can also talk to your family and friends, your loved ones, about your deficits as well. Sometimes we don't even realize that we have a deficit, and it takes someone who is looking at us from a third person perspective to see kind of the impairment that's going on in our life. So we would encourage you to make your list, and you can ask your family and friends when making your list, and we think it will be helpful for you. Walking hand in hand with making your list, it's a good idea to write down when you experience new or infrequent deficits. Sometimes we experience something new, and when we write it down, we can say to our doctor, look, last visit, I was not having problems with my speech, and now it seems that I'm having problems with my speech. Writing down something new reminds us to bring it up at the next appointment. Or infrequent deficits. Sometimes people are experiencing things and the majority of their function is impaired by one or two deficits. Sometimes there's little deficits that only occur once a month or may only occur once a week. And sometimes it's difficult to remember them because you're struggling so much with the deficits that occur all the time. So again, if you have a deficit that's new or it's something that rarely occurs, as you're experiencing it, we encourage you to write it down, because it will remind you when you go to your doctor that this is something that is happening, that you can communicate. Also, speak to your medical professional about medication and treatment side effects. It's important for you to know that for your own health, but it's important for your medical professional to know that so that they can diagnose whether this impairment that you're experiencing is actually coming from the brain injury itself, or it's coming from a medication that's been prescribed to treat the brain injury. And that's important too, because if you're having side effects from medication, in some cases, the physician or the treatment professional, they can prescribe a different medication that might give you less of that side effect. But it's also important to know that for your case, because if you're experiencing a brain injury and you're experiencing side effects from the medication, that's still something that is caused by the brain injury, because it is caused by medication that is required to treat that brain injury. You should also speak to your medical professional about treatment adherence. Are you sticking with the treatment plan? Are you taking your medication on time? Are you taking it every day? It's important for them to know, and it's important for your file to understand really what treatment is effective, what treatment is not effective, and being honest about whether you're adhering to your treatment or not is a good way for your medical professional to better treat you and better understand the trajectory of your symptoms. Also, use numbers to communicate symptom severity. You'll hear numbers a lot. If any of you have participated in a case or litigation and you went to examination for discovery, it's very likely that the other lawyer, the defense lawyer, asked you to put some numbers to your symptom severity. And I'll give you an example. A lot of the times, if someone says, I'm experiencing pain, they're asked to rate that pain on a scale of 1 to 10, with 10 being the most severe and 1 being not at all. And if you keep track and you communicate to your medical professionals your symptom severity, it's a little bit easier to track the progression over time. If you go to your medical professional over 2 years and the pain's a 10 out of 10 every time, then you really do know you're not getting better. If it's a 10 out of 10 and then it becomes an 8 out of 10 a year later, you know that there is some improvement. It is difficult to put numbers to pain and to symptom severity. And if you really feel like you can't put a number to it, then we would of course encourage you not to do that. But if you can, it's a good way to keep track of how things are progressing. It's a good way to provide a trajectory for your lawyer to use when assessing the value of your case and proving your case in court. All right, Stacey, if you don't have anything to add, I'm going to jump to the next one.
You're doing great.
Thanks. All right, now we get to affidavit of documents. So in a personal injury or negligence action, you're required to give to the other side any document that is relevant to your case. A relevant document can be related to fault. If you happen to have been in a motor vehicle accident, that can include things like a motor vehicle collision report. It could include photographs of the damage to your vehicle. Relevance can also relate to your injuries and your damages. Usually they're things like the clinical notes and records of anyone who's treating you. They might involve, if you have a motor vehicle accident, they might involve documents from your accident benefits claim as well. And it's very important for you to make sure that all the relevant documents get sent to the other side, because if you don't send relevant documents, then there can be consequences. At the lighter end of the spectrum, you might not be able to use that document later in your case. At the most severe, you can have your case dismissed. Now, when I say that, I don't want you to worry and think that if you forget one document that your case is going to be dismissed. That's not true. It's practically that often that we come with an affidavit of documents and it doesn't have everything. And when you go, after you give your affidavit of documents, you go to discovery, and at discovery, the other lawyer will often ask questions and will find out about documents that should have been in the affidavit, but were not for whatever reason. And the other lawyer is allowed to ask your lawyer to go right for those documents and give them to the other lawyer. And that's often what happens, provided those documents are relevant to your case. So to backpedal a bit, when your lawyer is making the affidavit of documents, it's important for you to think about what could be relevant to your case and whether or not your lawyer knows about that or has those documents in their possession. So you should tell your lawyer of any new places where you're getting treatment. Maybe at the first time you met your lawyer, and since you've talked, you've started treating with a psychologist when you weren't before. It's important to tell your lawyer about that so your lawyer can write for their records, because if you are claiming psychological injuries, they would be relevant to your case. Now, before I keep going, I think it's important to note that when we say documents that you have to give, the law looks at documents that you have and defines them as documents in your power, possession, or control. So possession means I have this document with me. Power and control relate more to, if I asked someone for this document, would they give it to me? And so even if you don't have your doctor's records at your house, if you were able to write to your doctor and say, please give my medical file to my lawyer, that will count as something that's in your power and control. So when you're thinking of documents that are relevant to your case, you should not only think about things that you actually have at your house or at your office, you should also think about things that you could write for and ask for, and your lawyer will do that for you. Some important ones that I think clients don't always think about is providing us, your lawyers, with any photographs you've taken of your injuries or of what happened at the accident. If you got in a motor vehicle accident and you took a bunch of photographs of the state of the cars after, that's relevant information. And it's good to tell your lawyer about those photographs and provide them if you have them. And if you don't have them, tell your lawyer as well that, you know what, I took these photographs, but I don't know where they are. Because documents that are no longer in your possession, but they used to be, are also required to be listed in the affidavit of documents. Also, your injuries. A lot of people, when they're in hospital after their injury, they have pictures taken of them, things that illustrate, how severe things were. That's relevant. That's something that can go to your lawyer. What's also relevant is pictures of activities that you used to do before the collision. So if before the collision you used to run marathons and after the collision you're not able to anymore, some photographs of you participating in a marathon might be relevant. Now, photos of everything you did before the collision would not necessarily be relevant. You don't need to send your lawyer your entire photo album, for the years before the collision, but talk to your lawyer and ask. Your lawyer will probably have an opinion on what kind of photographs about what kind of activities would be relevant for your case. Another good thing to speak to your lawyer about is any social media that you're using. A lot of people are surprised to find out that in some cases, social media is relevant and it's something that the other side is going to ask for. We would recommend that once you start your case, you be very conscious about what you're posting on social media, because if you're posting something that relates to your case, it could very well be relevant and you could be required to give it to the other side. Sometimes the other side will conduct surveillance on you. And part of that surveillance will be looking at your social media pages, especially if they're public, and taking screenshots of posts that you may have posted about your injuries and impairments or things that relate to them. So before your examination for discovery, tell your lawyer what social media you're using, what accounts you're using, what kind of things you've been posting. Your lawyer will be able to tell you whether that stuff is relevant or whether it's not relevant. Another common one that people don't realize is journals and diaries. The other lawyer, the defense lawyer, will often ask whether you're keeping a journal or a diary related to your functioning. In a lot of cases, if you've been keeping a journal or a diary and you started keeping that journal or diary when you knew that you were going to start a court case and you kept that journal or diary for the purpose of the court case, that's not always something that's relevant because it's protected by something called litigation privilege. But if you are keeping a diary or journal, you should tell your lawyer regardless. And the lawyer will have they'll be able to ask you some questions and have a better idea of whether this diary or journal is something that's relevant, that should be going in the affidavit of documents, or it's something that's privileged. And if it's privileged, then we would list it in the affidavit of documents and say, look, this is privileged, so we're not going to give it to the other side, but the other side should know that it exists. Sometimes the other side will simply ask. And if you're caught by surprise at your discovery about having a diary or journal and you say, you know what, I do have this, it's better for your lawyer to know beforehand rather than learning this at your discovery. And there's probably a few things I'm forgetting as well that are not so common, but it's a good idea when your lawyer is making that affidavit of documents to really sit down and think to yourself, what is relevant? What is going to help prove or disprove my case that's in my possession? Because even if something is not good for your case, if it's relevant to your case, that means you still do have to produce it. So take a second, take a few minutes, take a day while your lawyer's drafting your affidavit of documents when you're at that stage of your case, and really think about, what do I have that's relevant? What could I write for that's relevant? What does my lawyer need to help build my case? And talk to your lawyer. They will be able to coach you through what is relevant and what is not relevant.
And Adam, I'm wondering, I have a member who's asking about messy notes. So I guess if there's just things that they've jotted down over time, would that be something to keep and present to your lawyer?
Yeah, so I think that's a really good question. I think, a lot of the time we make little notes and we chuck them out because we put them on, sticky paper. I've got a whole stack at my office of sticky paper that I put these little notes on. I think, if it's something that's related to your impairments, then you probably should keep it to talk to your lawyer. But if you're making these notes and you're losing them or they're being thrown away, I wouldn't really worry too much about it, because, the majority of your injuries and impairments are going to be recorded in your doctor and treating professional's notes, or they're going to come out through your own words that you say at the examination for discovery. I think it's more, what the other side's going to be more concerned about is if you have a journal that's tracking things over time. If you have notes that have your symptoms on them and there's not really a date, or there's not really anything, specific on there, those might not be as relevant as something that really tracks things and gives times and dates. So, the short answer is, look, if you're, writing sticky notes about your injuries and impairments sometimes, and you lose them, I wouldn't worry about them. If you do have them in your possession and you know where you are, you should talk to your lawyer about them. In most cases, if you're writing these sticky notes after your case is started, they are going to be protected by litigation privilege. So they're not something that you're going to have to give to the other side anyways. But Stacey, unless you have anything else to add, I think.
No, I think that, just about covers it. Sometimes when you're on discovery, there'll be a common question. For example, the defense lawyer may ask you, did you make any notes after the accident? And if you did, for whatever reason, those are probably relevant. But the tricky part with journaling is, and for those of us who do it, right, everything that you write down is not necessarily going to be relevant to the accident. So like Adam had said, it's only information that is either relevant to the issues, or there may also be stuff that's caught in there for a litigation privilege. But if you've just got some pages and, from time to time you jot notes down, again, the best thing to do is show them to your lawyer and talk to your lawyer and find out ahead of time. There's nothing worse there's lots of things worse, but from our perspective, when we're on an examination for discovery and our client all of a sudden blurts out, well, I've been keeping a journal, I've been keeping a diary. The first thing that sort of goes to our head is like, oh my gosh, okay, what's going to be in there? Because lawyers by nature are just really curious people. And so there's going to be questions that are going to be asked to you that you may not be prepared to answer. And I think that's probably the most important takeaway, is that, you need to talk to your lawyer about everything. That way we can prepare you, right? We can't prepare you for what we don't know exists. So yeah, just bring it up to the lawyer. And if the lawyer says, look, I'm not worried about it, it's not relevant, but don't mention it during your discovery, then you have to follow their advice. And just to pick up on one little thing, Adam was talking about, writing for documents and stuff. Don't get too overwhelmed. That's something that we do. A lot of times what we ask for is just a list, right? We get all the documents that we need for your case with your assistance, but it's certainly not a task that you have to be worried about taking on yourself.
Melissa, sorry, I hope that answers the question. If it didn't, they can circle back we're going to do a little question period.
Yes, definitely.
They can circle back again.
So they did say that did answer the question. They thanked you. And another question came up. Should 1 to 10 pain statements have a descriptive sentence of what number 6 means, so that we're both on the same page?
Yeah, that's great as well. That's a good way to do that. It's a good way to give more information, because you're right. 10 pain that's 10 out of 10 to me means pain that might be different to someone else, right? And you want to give context, because there are people who experience pain differently. I think that again, that could be something that's good to talk to your doctor about and say, look, I feel like it's 6 out of 10, and for me 6 out of 10 means every time I try to stand up, my head hurts, and it feels like it's crushing, like a crushing feeling on my head. So it's good to give that context. Definitely. Yeah. The more information, generally, the better.
Thank you.
Okay, so if there's no more questions, we'll move on to the next one. Okay, so now we get to examination for discovery. And just as a review, an examination for discovery is when the other lawyer gets to sit you down, and it usually takes about a day, and they talk to you about everything that's going on in your case. They talk to you about the accident that caused your brain injury. They talk to you about your brain injury. They talk to you about the effect it's had on your activities of daily living, on your ability to do housekeeping, on your social relationships, on your ability to earn income. They cover everything that's relevant to your case. So after the other lawyers received your affidavit of documents, you enter this examination for discovery, and it's now, after COVID, it's usually over Zoom just like this. You may be sitting there, and there's going to be one window which has a lawyer like me who's going to be asking you questions, and he'll be for the other side, and the other Zoom window, you'll have a lawyer like Stacy who's going to be sitting there and making sure that the other lawyer is asking you questions that are appropriate, and they're not asking you questions that are not relevant to your case. So when you go to your before your examination for discovery, talk to your lawyer about your injuries. They're going to usually have a preparation meeting with you, and you're going to go over what you're feeling and what you're experiencing. And this is a time, again, to think about your injuries and how they've impacted your life, your job, your self-care, your housekeeping, your social activities, even your hobbies, because your hobbies relate to what's called genital damages, which in the law means your pain and suffering. And if you were a great chess player and you loved to play chess before you suffered your brain injury, and now you can't play chess, that's part of your claim. where you can get money for the suffering that you have for not being able to participate in activity that brought you joy. So really think about that and think about how it's affecting your life and how it might have changed. Also talk to your family members and friends and loved ones again about how your injuries have impacted your life. Just like I said in the previous slide, when we were talking about starting your case, they're going to have insights that you may not have. And it's not because you're not paying attention, but it's just because sometimes other people see us in a way that we can't see ourselves. And you might say, you know what? I'm pretty good. I don't miss appointments. And they might say, well, you missed 2 appointments last month and you missed 2 appointments the month before. And you might go, oh yeah, I did, and that might give you some insight that you didn't have before. And it's important to know that because always, always, always at discovery, you always tell the truth. And that's the best thing you can do for your case. And every lawyer is going to tell you the same thing. And if the other lawyer sees perhaps in your doctor's records that you said, you know what, my pain is 10 out of 10, and you go to discovery and you say, my pain's 8 out of 10, they're probably going to ask you, oh, has it changed? Has it improved? And so by talking to your lawyer about your injuries before your discovery, your lawyer can know if they've improved or if they've gotten worse, and they can prepare you to answer questions like that are, probing or trying to figure out why things may have changed. And again, just because you say something different than you might have said to a doctor in the past, it doesn't mean that you're lying or being dishonest. It might just honestly mean that things have changed. So another thing that you can do is ask for accommodation during your discovery. A discovery is your show. Usually what happens is, especially in the case of a motor vehicle accident, you have your discovery, you show up at around 10 a.m. And from 10 a.m. to about usually the first hour, your lawyer will ask questions of the person who injured you. Usually it's the other driver. And then at 11 a.m., you'll come back into the discovery. You'll re-enter the Zoom meeting because you won't be there when your lawyer is asking questions of the person who hurt you, and your discovery will start. And it goes from 11 and it can finish very quickly, or it can go till 5. Sometimes you'll have to come back another day. So it's your show. You're allowed to ask for breaks. For people who are living with brain injury, I know that staring at a screen can be quite painful. It can be quite draining. You can ask for a break. I've had clients who needed a break every 20 minutes. They needed a 5-minute break. I've had clients that need lower lighting and volume accommodations. They can turn their own volume down. They might ask people to turn the lights down in their respective rooms. You may turn the lights down in your own room. You can wear sunglasses if those lights really bother your eyes. You can wear noise canceling headphones if even at the lowest volume, it's a little too loud. It's important to know that we don't want your discovery to make your injuries and impairments worse. I think inherently in the discovery process, it's not going to be comfortable. And, there's a part of it where it might be, especially if your injuries and impairments are really related to, phonophobia, photophobia, lights, hearing, it may be uncomfortable, but we want to minimize that discomfort as much as possible. And this last little one, during your discovery, do not be a martyr. Now, that's a saying that I used to get from my summer camp coordinator when I was working. And don't be a martyr means don't be a tough person. Don't minimize your injuries and impairments. Don't say you're doing okay when you're not doing okay. A lot of people that live with brain injury are tough, and they're hurting, and they're doing the absolute best that they can do to move forward with their life. And they don't want to worry their family members, so they don't want to talk honestly about their symptoms. Your discovery is the one day where you don't do that, okay? Your discovery is the day where you are honest and you say, look, this is really how this is affecting my life. No one's going to call you a complainer. It's what you need to do to make sure that the other side knows that, this is really what's going on with you. And this is really how your life has been affected. Because whatever you say at discovery is going to go into a book. And it's going to be a written transcript of exactly what you said. And when you go to trial, if you say something different, you give different evidence than you did at your discovery, the other lawyer is going to pick that book up and they're going to say, well, you said this at discovery and you're saying this at trial now. Why is there a difference? So at your discovery, you should treat it like you're up there at the trial and you are being, candid and truthful about what your how seriously your injuries are impacting you. And, I think a lot of people have the stereotype that people in personal injury cases over-exaggerate their injuries. But what Stacy and I have found working in this area is it's actually the opposite. People usually downplay their injuries. People usually are trying to appear strong for their friends and family. But discovery is not the day to do that, okay? Don't be a martyr, be honest. Don't be afraid to explain exactly how these are affecting your life.
Those are great pieces of advice. Adam's very good at covering off the technical aspects of a discovery. But, we get a lot of common questions when we do these things, especially from our clients who are brain injured. And one of them is, can I have someone with me? Can I have a support person with me? Because we recognize that there's a lot of anxiety and other issues that, that you're dealing with. And unfortunately, actually, I shouldn't say it that way. The answer is sometimes, with anything in law, we never give you a straight answer, right? We're always giving you a maybe or, well, it depends. And it does depend. I've had situations before where I've had a client whose family member has sat in on the understanding that, you don't get to answer questions. You don't get to look to that person for assistance. The questions are still yours to answer. As well, the lawyer is going to be with you so there will be periods of time where you will feel very overwhelmed and you'll feel very, very anxious. But keep in mind that if you are someone who's going through this process, this is unlike what you see on TV. And you're not going to get someone who's coming at you, being argumentative, asking yes or no questions, nothing like that. That's not what happens at the discovery. It's as much as it's a formal court process, it's very informal. And like Adam said, you're entitled to ask for frequent breaks. And I think the important thing to keep in mind is that you control the day. You really do. So we understand that there are issues with stamina. There's issues with fatigue, right? Cognitive fatigue, mental processing, all of those things. So quite often our clients will be very concerned that they're going to have to sit there for the whole day and they're not going to make it through it. But that's not what happens. Many, many times we've ended discoveries after 2 or 3 hours because you can tell just by looking at the client that they're fading. And no one wants you to be giving evidence if you're not in the best shape to give your evidence. The other thing to remember is if you don't remember, and that's a common symptom of people with brain injuries, if you don't remember, you just don't remember. That's the answer. 90%, probably 95% of the answers are already in the medical records. The discovery is really an opportunity for the other side to see you, to get to know you, right? To put a name, a face to the name. So yes, it can sound to be a very, very daunting day, but your lawyer will take great pains to make sure that you're properly prepared. And the reality is that pretty much anything you say can be changed. There's not a lot that you can say in terms of answers that will completely ruin your case. If you give incorrect answers, we're under an obligation to change them later.
Okay, and that's great advice too from you, Stacy. I'm going to just move to the next one now. Okay, before the mediation. A mediation, just for a little review, is usually after your examinations for discovery, you get in a room with your lawyer and the other lawyer gets in a room with their client, which is usually an insurance adjuster, and you try to mediate your case. A mediation means that a mediator, who's someone who's impartial, they hear both sides of the case. Usually it's done through a mediation memo, which is just a document that your lawyer will make and the other lawyer will make. And they may make some submissions or they may make some standing argument at the mediation, but most of it is just you sitting there and settlement offers going back and forth. So when you're leading up to mediation, you should be thinking and hoping for the end of your case. If you guys can't come to a settlement, then you move to the next step, which is trial. If the mediator is not really going to give a solid opinion on who's right and who's wrong or how much money each of you should get. They're just there to help you guys discuss and give you a third person perspective. So when you're leading up to the mediation, the hope is that you're going to settle your case in mediation. So you should plan for the end of your case. And I'm going to let Stacey kind of jump in here to talk about whether a structured settlement or lump sum is right for you and what a guardian of property means.
So if you're able to get your case settled at trial, if it's a significant amount of money, you're going to have the option of investing it in what's called a structured settlement. I'm going to talk a little bit more about that. In terms of guardian of property, if you're someone who your brain injury has left you with an inability to make financial decisions or an inability to make proper decisions with respect to your personal care, you'll need a guardian of property at that point. And that's usually something that's determined by a capacity assessor. Sometimes it's done at the beginning of the litigation. Sometimes it's done at the end. We may not always have a good understanding of how serious your injuries are and how much they impact you until the case develops a little bit more. But a structured settlement is an investment product, so to speak, that is available only to people who are injured in personal injury claims. So if you get an award for damages, you meet with a structure broker, you have family members who support you. If you have a guardian of property, then that person supports you, that person makes the decisions with you, and you determine the best way to invest the funds to ensure that they last for the rest of your life. But the benefit of the structure is that it's tax-free. If you took your settlement and you put it into an RRSP, you're going to pay taxes on the investment income. If you put your money into a structure, it's going to earn guaranteed interest rates and the money will be tax-free that you earn. The capital that you put in is tax-free as well. Structures are generally built, like I said, once a case has been settled. Sometimes they are built prior to having to get court approval of a settlement. So if you're someone whose brain injury is quite significant and you need a guardian of property, the person who's your guardian of property isn't going to be able to say, sure, we'll settle this, your claim for $20,000 because they just want to end the litigation. The court's going to have the final say. They're going to be the ones that say, is this a good settlement for you? Is this a good structure for you? Or should you be looking at different options? A structure is something that's kind of, if you think of it like a pension in a way. So once you know how much money you're getting for a settlement, you meet with the structure broker. Maybe you have your case manager there, your occupational therapist there. You want to have somebody with you who can help you really identify your key treatment needs. Because up until this point in time, you've had a wonderful supporting treatment team. You've had a lot of people around you, a lot of people helping you. And when we get to settlement, once the claim is settled, I find that a lot of our clients feel quite lost, right? You feel abandoned. Your lawyer's gone, your case manager's gone. All of these people who had you in this lovely, sort of nest to make sure that you were going to be okay and you're getting all your rehab, everybody's gone. And a lot of times clients get very confused and they get a little scared when that happens. So what we always very strongly recommend is that you meet with the structure broker. And I saw a quick question point pop up. There's only a few in Canada. The one that we tend to rely on more than the others is McKellar's, and that's McKellar. Only very specific licensed brokers can do this. You can't get one from your bank. You can't get one from your investment guy. You have to go to a structured settlement broker. So anyways, you meet with your treatment people. You figure out what are your key treatment needs. Do you really need occupational therapy, every day? Or can you whittle that down? Do you really need physio, RSW, massage? So you go through that process because the beauty of the structure is it can be set up and designed in absolutely any way that meets your needs. So for example, let's say you had a large settlement, let's say it was $1 million, right? You can put your $1 million into a structure. You can take regular monthly payments for a year. And then maybe at that point you say, you know what, I want $350,000 out because I want to put a down payment on a house. So they build in lump sum payments. It can increase based on cost of living. You can you can name a beneficiary. So if something happens to you and you pass away unexpectedly, your estate can still get the benefit of the structure. But these are all things that a good structure broker will go over with you before you sign on the dotted line, so to speak. But the biggest sort of benefit to all of this is really that the money that you earn on your structure is tax-free. And for people who are really young as well, I know for a lot of my clients who are sort of in their early 20s, they've got a long life ahead of them. And if you're someone perhaps who has a brain injury, but you're still able to work, even if it's just part-time, or you're working, but you may not be able to stick it out forever, you can defer your structure payment where it's, my structure payment is going to kick in when I turn 40, because that's when I think I'm going to have to taper down my ability to work, right? So it's the beauty of it is it can be anything that you want in order to meet your needs. And I'm a little cognizant of the time. I know we only have until 2, so I'm going to skip ahead just a little bit to sort of keep talking.
And Stacey, sorry
Yeah?
to interrupt again.
That's okay.
There is a question that came up, and it is there a title or name of a settlement structure, like a pension type?
Not really. It is just called a structured settlement. That's the term.
Okay.
And like I said, there are a number, 1, 2, 3, I think maybe only 4 or 5, maybe 6 licensed structure brokers in Ontario. And that might even be Canada-wide.
Oh, wow.
Yeah. It's a special type of work that they do. And the other thing to note is that you don't pay the structure broker any money. If you invest your money at the bank or Manulife or London Life, they earn commission, right? Based on the investments, based on the income that it earns. That's not what happens in a structure. You're not responsible for paying them any fees. Everything is generally either it's generally paid by the insurer. That's the short answer. But let's talk more about that, because also keep in mind, now that your claim is getting close to settlement, have you looked at an RDSP, right? The Registered Disability Savings Plan. Have you applied for the disability tax credit? Have you thought about CPP disability? These are all other we'll call them social government safety nets that can help be put in place to maximize on the funds that you have available to you. Because unfortunately, with litigation, 98% of our cases probably settle before trial, which is great news for you, because the last thing you want to do is be stuck in a trial. But that also means you're compromising on the money you're getting. So you're probably not going to get 100 cents on the dollar for what your case is actually worth. The other thing is that as drivers, we have insurance policies to respond to claims for people who have been injured. Most drivers only carry $1 million. Some carry 2. Trucking companies, big companies, they carry a lot more. But if you're a young person and you have a severe brain injury and you need someone to be looking after you 24 hours a day, 7 days a week, that $1 million that's going to be available from the defendant's insurance company, it's not going to be enough, right? So it's really, really important to look for other ways to subsidize, or not subsidize, but to contribute to the income that you're going to be having coming in. And one of the questions that a lot of clients ask us is, well, what about ODSP? Either perhaps you're already on ODSP when the accident happens, or because of financial circumstances, you end up on ODSP after the accident. 2 things to keep in mind. ODSP, if you're on it before or you go on it afterwards, they might ask you to sign what's called an assignment. An assignment means that you're going to promise to repay ODSP the benefits that you're getting during the course of the litigation and perhaps future. There's some caveats to that. If you're getting money for future care. If you're getting money for general damages for pain and suffering, that's exempt. If you get money for income loss, or if it's an accident benefits claim and you're getting money for a non-earner benefit, those monies are considered to be income by ODSP, and that portion of your settlement will have to be repaid. The other side of that is that when your lawyer is negotiating settlement, if that's a situation that you're facing, your lawyer will work with the other side to divvy up each and every head of damage that you get and allocate this much for loss of income, this much for non-earner benefit, this much for the other categories. Also, if your injuries are really bad, where you're going to need the money that you've got isn't going to be enough, there are ways to get ODSP to completely waive the assignment. So don't be too taken back by the notion that, oh my gosh, I've gone on ODSP and now I've got to pay all this money back. There are ways that there are workarounds, and your lawyer will work with, like I said, the other side. They'll work with ODSP to try to reduce that overpayment as much as possible. Can you work after the claim has settled? That's another common question that we get. And the answer is yes. Yes, you can. No one's going to come back after settlement and say, oh, excuse me, Adam, we just paid you $1 million, but now we see you're working at the local gas station or at Tim Hortons, or you're, a receptionist at the real estate office. No one's going to do that. So yeah, if you can work after the accident, don't be worried about getting out there and trying to do something for yourself. Litigation is long. Litigation is stressful. Litigation has the ability to make you see all the bad, right, in your life. Because unfortunately, as much as we want you to get better and we want you to rehab and be the best you can be, we also spend a lot of time on the other side of the fence talking about how bad your injuries are and your impairments are. So at the end of the day, yeah, if you can get back to work and do something so you feel good about yourself, you can do that. Actually, even during the course of litigation, I will encourage my clients to do the same, even if it's volunteer work. What's most important is that you do what's best for you. No one is going to come afterwards and say, oh, well, we gave you, $500,000 to pay for future rehab treatments. How much have you spent this year? Have you spent it all on your rehab treatment? No one's going to come back and ask you those questions. Unless, remember what I said, lawyers never give a straight answer. Unless you have a guardian of property. So if the court appoints, let's say, your spouse, your mom, your friend, whoever, a bank, to be your guardian of property, that person is going to be responsible for reporting back to the court how they've spent your money. And that's just the court's way of making sure that someone with a brain injury hasn't been taken advantage of financially. What other questions? Divorce. So what happens if you're married and then you get divorced? From the case law, first of all, always speak to a family law lawyer, especially if you're at the point of negotiating settlement and it's going to be a large settlement. Take the time, get a consultation with a family law lawyer. By no means, Adam and I are not family law lawyers, but settlement in a personal injury claim that's invested into a structure, it might be classified as income for the purposes of the division of your net family property. So that's just another something to keep in mind. I can't give a real definite answer to that because it's really not within my scope of practice, but it's always a good idea to just keep that going. We've got about 4 minutes left, and I know we kind of rushed to the end just because of our timing. Does anybody have any questions?
There is one, I'm just trying to clarify it, but the member has said settlement structures and other subsidy for future Zoom. So I'm not certain, just gonna try to clarify it.
No problem. So are you asking that we come back and do just a webinar on structured settlements and other type of disability supplements that are out there? We could talk forever about that.
Oh, so I got a yes.
Okay, that would be awesome. I'm always happy to talk. I think that, education and knowledge is power. So the more information that we can give to you, to your care providers, the more powerful you are in making your decisions, right? Especially when you're getting into an area where, you're sitting at a mediation table and, your lawyer's looking at you, the mediator's looking at you, and everybody's going, well, what do you want to do? Do you want to settle? What should you do? It's always good to have, a little bit of information in your back pocket to feel confident about what you're doing. And also, I don't know if I mentioned this, but at mediation, you can have anybody there you want. It's not like discovery where we have to ask permission from the other side. If you can have someone with you, we've gone to mediations where parents have been there, husbands have been there, RSW has been there, OT. You can bring your support network to help you work through making any decisions that you need to make.
Thank you. Like Stacey said, we do have a few more minutes. And so if you do have any questions, if you can't type quickly, I completely understand. If you want, you could just press any button and hit enter, just so that I know that you have a question coming. Otherwise, we will be ending fairly shortly. But I think that that's really great. I mean, we do the PIA webinars, my apologies, twice yearly. And I think that, this is the first time that I've been able to, sit and listen to some of these topics. Settlements, you don't really think about them too frequently because it's not something that most people have to consider or think about. And it seems like it really is such a complex topic, and I mean, for a lot of our members, they do kind of face that.
Yep, it can be, especially when someone sits down with you and says, okay, let's make a decision for the next 40 years of your life as to how you want to plan to spend your money. Right? That can be tough. What's the other thing? A will. We don't think about it very often. Especially as lawyers, I know I need to get mine done soon, but that's besides the point. But when your action is done, make a will. Do yourself a favor. Do your family a favor. Make sure to put that in place as well, right? Not that you expect anything to happen to you, but it's good practice. Especially again, if you're just somebody, maybe you have children. Again, depending on the size of your settlement, that might be what you want to do. But yeah, coming back to talk about structures would be a really good idea. There's lots of questions clients have asked, can I use my structure as collateral to get a mortgage, right? You might want to use part of the money to put a down payment on a mortgage, but then is the mortgage company going to look at your structure income as income? There's so many things to think about with structures, but yeah, we'd be happy to come back, and probably we'll bring someone from the structure company with us to give a little bit more insight into that topic as well.
Wow, that would be fabulous.
Yeah, I got a little pull there,
So the other question is more coming in structure companies. So I wonder if she's asking, is there more information coming?
Yeah, we'd be happy. We would be more than happy to come back and talk all about structures. And yeah, we'll definitely bring someone from a structure company. Is there more that are sort of opening up as time goes by? That I don't know. Like I know there's McKellars, Baxters, Hendersons, and I think there might be one or two other small ones. But is this an industry that's growing? I don't know. Like I said, they're specially licensed companies.
Mm-hmm.
And I think
that was her question.
Yeah. And I think a lot of it is just because the type of investment that it is, it's an annuity, a life annuity, but it's set up also the investment income is tax-free, which I would suspect is why, sorry, I just saw the next question that popped up, which is probably why there's very limited structure companies out there. But I see there's a question about it being more than 2 years since your accident. The answer is it depends. The rule is, it's a discoverability rule. So it's 2 years from when you knew or ought to have known that you had a cause of action against a claim against the at-fault person. But there are some exceptions if you have a brain injury to the extent that you need what's called a litigation guardian. That's different than a guardian of property. The litigation guardian is somebody at the beginning of the case who gives us instructions on your behalf. Guardian of property is someone who comes in at the end of the case. Yeah, under those. That's right, under the Limitations Act. Very good. Yes, so the guardian of property comes in more at the end. So if you need a litigation guardian, you don't have one, or if there hasn't been a finding that you need a litigation guardian, it might be possible. Again, it really does depend on the circumstances. And I'm always happy to chat if you want to pick it up offline, and we can answer any other questions that you might have.
Yeah, I mean, and if you do want to get into contact with Stacey or Adam, you can also just email me at connections@this, and I can put you in touch with the right person.
Yeah.
There we go.
There you go.
I had a feeling that's what we were doing.
Yeah, we'll just pop ahead to that one. Okay. Yes, so that is me, and then we have Adam's contact information available as well.
Perfect. Okay, and if there's no other questions, then I think we'll end it here. I just want to take a moment and sincerely thank Adam and Stacey for joining us this afternoon. This was a really incredibly informative afternoon. I know that a lot of members were very happy to be getting this information. I was reading the comments in the chat box. So thank you for attending
our pleasure.
Here at BIST.
Pleasure, guys.
Thank you, and we will see you. As everybody knows, we will see you in spring for our next PIA webinar sessions. But yes, thank you so much.
Awesome. Well, thank you, everybody. Thank you, Melissa, for having us. And thanks to everybody who attended. Hopefully we kept it interesting. I know law can be a bit boring and everything else, but hopefully we answered some of your questions.
Thanks, everyone.
Thank you.
Take care.